Hello, Michigan Realtors, and welcome back to the Letter of the Law. Over the last 2 months, we have been discussing the forthcoming practice changes set to be implemented by August 17th. One consideration that we haven't explored yet in detail is where the settlement leaves procuring cause as we have long understood it. With offers of cooperating compensation moving off MLS, there are some important considerations for brokerages to address to limit the likelihood of disputes related to compensation going forward. In this installment, we will look at a few hypotheticals that highlight some areas of concern. Under the rules as we have known them for decades, offers of compensation are made through the MLS to the procuring cause of the transaction. Now, the rules for determining procuring cause are found in the arbitration manual. Those rules protect listing brokers from having to pay two different brokers who each claim to be the procuring cause of a particular transaction, provide that a cooperating broker does not get paid if the transaction doesn't close for whatever reason, and in some circumstances, excuse the listing broker from paying the cooperating broker if the deal closes, but the listing broker does not get paid for some reason. Going forward, if a seller authorizes the listing broker to make an offer of compensation to cooperating brokers, this offer will need to be made outside of the MLS. This offer of compensation will be a matter of contract between the listing broker and the cooperating broker. In the event of a dispute, the matter is still subject to arbitration. However, the panel will be called upon to interpret the parties' actual contract. It will no longer be the case that the procuring cause, and only the procuring cause, is entitled to payment. Going forward, listing brokers will need to use broker-to-broker contracts that clearly spell out the terms under which the cooperating broker gets paid. Consider the following hypotheticals. Listing broker advertises 123 Main Street on its website. The advertisement states, with the authorization of the seller, that the listing broker is offering a commission to cooperating brokers in the amount of X. Now, broker A schedules a showing for buyer Smith, who tours the home with buyer Smith 3 more times over the next week. Buyer Smith then submits an offer on 123 Main Street through his cousin, broker B. Now, the listing broker can no longer rely on the procuring cause rules to sort out the dispute between broker A and broker B. This will need to have been covered in the contract for the cooperating compensation. If it wasn't, the listing broker could owe both broker A and broker B. If a broker offers a commission split on its website, the offer should make clear that it is not binding without a written broker-to-broker contract. A listing broker does not want a cooperating broker to be able to argue that it has accepted the website's offer by producing a buyer. Another hypothetical. Broker A seeks to schedule a showing on 222 Elm Street for buyer Green. Buyer Green ends up submitting an offer through broker B. Broker A claims that during the initial call, listing broker promised to pay broker A a commission of X amount if the Greens bought 222 Elm Street, since broker A introduced the Greens to this property. Now, listing broker claims that this offer of compensation was conditioned upon broker A actually writing the offer. But under Michigan law, oral agreements between brokers to share a commission are enforceable. So the outcome would turn on whether the listing broker or broker A was more believable. The fact that listing broker also had to pay broker B would not be a defense. Any informal discussions of a possible commission split, whether oral or via text, should make clear that a written broker-to-broker contract is required. And a final hypothetical. Broker A submits an offer for buyer Jones on 234 Oak Street, which is accepted by the seller. The listing broker had advertised X amount of cooperating commission on this home. Now, seller defaults and the deal doesn't close. Broker A takes the position that the listing broker's offer of compensation was earned at that time that he produced a ready, willing, and able buyer. After all, it is not his or his client's fault that the seller defaulted. Now, the listing broker's position is that the offer of compensation was contingent on closing. But if the contract is silent on this point, or if there is no written contract, it is not at all certain which way a court would come out on this. Written broker-to-broker contracts should clearly state that no commission shall be owing unless the transaction closes. Now, as we do these mental gymnastics, we quickly recognize the need for a thoughtful brokerage policy related to both offering and earning compensation. Michigan Realtors will be developing a sample form of a broker-to-broker compensation agreement, which will outline requirements for payment. However, in addition to using a carefully crafted written contract, brokerages will need to implement policies aimed at protecting the company from commission claims from brokers other than the broker with the written contract. All listing agents must understand that if they commit to a commission split orally or even via text, their broker may be bound by that promise. Any discussions of a possible commission split should make clear that the discussion is only preliminary and that there is no obligation unless and until there is a signed contract. So thank you for tuning in, and we will continue to provide more analysis on the forthcoming practice changes. If you have not already done so, please register for the upcoming broadcast event on June 20th entitled The Conversation. Now, during that broadcast, President Sandy Smith will engage in a candid conversation with Michigan Realtors legal counsel, exploring some of the most commonly asked questions pertaining to the settlement. Register today and submit your own question to be addressed during the event. We hope to see you there.